All right, so this week we are talking about environmental impacts, looking at CEQA and NEPA, and then talking a bit about climate change and air quality. So let's go ahead and get started. First of all, hopefully one of the themes you're picking up on is that wildfire law doesn't have specific categories of law that directly address wildfire issues. And so we're left up to these other programs to help address that. Two of the bigger ones that you have in your tool belt are NEPA and CEQA, the National Environmental Policy Act and the California Environmental Quality Act. And then we'll talk a little bit about Clean Air Act, and I think we'll put off the Clean Water Act till next time, next week. So let's talk about economic strategies for pollution control, right? Just as an example, right? We have command and control regulations, we have incentive-based regulation, or we have information and disclosure. That's how we deal with environmental issues, right? The government either comes in and says you can or cannot do these things. They provide incentives that say, if you do this, we'll give you a tax credit or a tax break or something. And then there's information disclosure, letting the public know exactly what's going on with regard to environmental impacts. And that's what NEPA and CEQA are all about, this last one of information and disclosure. NEPA was passed in 1969 under the Nixon administration. The purpose was to declare a national policy on the environment, to recognize that humans are having a substantial impact to our natural resources, and to be able to limit the damage done. And so it's as much of a disclosure document as it is a public policy document to help folks understand what the environmental impacts are and have a very public, very open and transparent discussion about what can be done to make it better if possible, right? So it improves decision-making and it informs the public. So it discloses a lot of things. The first of all, most important is environmental impacts of the actions that folks are taking. And by actions, what I mean is any project within the federal purview that has what we refer to as a federal nexus, right? So if the federal government is in any way involved in a project, then it requires NEPA review. And examples of that are things like, obviously anything that's built or done on federal lands, clear federal nexus, right? But it also means if, say, a city is building a freeway interchange and it uses federal dollars as a grant fund, well, that's a federal nexus as well. Or it goes as far as to say, if the federal government has any permitting authority or oversight of that project, that also instigates NEPA. It identifies what the environmental effects are that cannot be avoided. There's a whole section that talks about alternatives to the proposed action. So yeah, we know you want to build a visitor center at the national park, but does it have to be there? Does it have to be that size? Does it have to be that particular, orientation or location, right? The other thing it does is it describes irreversible and irretrievable commitments of resources. So what exactly is the federal government committing to in this process? And then it also helps us understand the relationship between local short-term uses of the environment, things like staging areas and other things that might be short-term impacts, and the maintenance and enhancements of long-term productivity. So if we are going to protect our natural resources, what kind of commitment is being made in order to protect those? There's this thing called the Council of Environmental Quality. It was Title II of NEPA, created the CEQ. It's 3 members that are appointed by the president. And annually, they prepare reports on environmental quality, regulations, or I should say recommendations on environmental policy, and they document and define environmental trends in the United States. Now, a lot of folks don't even pay attention to this or even know this happens, but the CEQ has been around for a long time and doing this sort of job. And it also develops guidelines under which NEPA operates. And those guidelines are updated on a regular basis. So let's say we have a project and we want to find out, first of all, does it qualify for environmental review under NEPA? Is there a federal nexus? And this is what I talked about earlier. Is there a permit the federal government's providing, discretionary funds, funding of any kind? discretionary decisions that are being made by the government at some level, providing you with some kind of oversight or approval? Is it on federal lands, or is there some other federal nexus? And then the next question really is there a land use change or action that could have an impact on the environment? So you have a few sort of documents available to you. You have exclusions or exemptions, the environmental assessment, or a full-blown environmental impact statement. Now, exclusions are pretty straightforward, right? There's a whole category of things that are listed under NEPA where they say there's not going to be any significant impact to the environment. And because of that, you don't require a full-blown environmental review, and these categories of projects are automatically exempted from environmental review. That's great. It really, it's for projects like, let's say you're trying to restore habitat, right? If your end goal is to provide an environmental benefit and there are no environmental negatives, that can fall under certain categories of exclusions, right? The other kind of thing, document, the next level up, is called an environmental assessment. Now, this is a very short version of, an environmental document that basically determines if a full-blown environmental impact statement is actually necessary, right? If not, if we find that the project has findings of no significant impacts, or what we call a FONSI, if the FONSI is identified and they say, well, there's, you've got a project, you're building this trail, but there's no significant impacts to the environment, then basically the FONSI sort of presents why there are no significant impacts. And again, it's just sort of a perfunctory process, right? Now, I will say, though, don't forget that every path along this journey here, the public has an opportunity to comment and make sure that they, and be able to provide input, whether they agree. Now, when I say the public, I also mean all other state and local government agencies and other folks that might have an interest in the project as well. Now, the EIS serves as basically an action forcing device, right? It ensures that the policies and goals defined under NEPA are part of federal action. And there were a bunch of court cases early on. Actually, a couple of the earliest ones dealing with NEPA had to do with nuclear power plants. And they kind of thought they didn't have to follow any of these rules because you have to remember, Department of Energy and all of that at the time was a pretty big deal. And so they felt like they didn't have to be in compliance. And the Supreme Court got all the way up to there and they said, no, you have to go through this process because we want a full and fair discussion of environmental impacts and a discussion of reasonable alternatives to those impacts. And so you have to file a notice of intent to the Federal Register, and you have to allow for at least a minimum of 45 days of public comment on that. Now, when I talk about alternatives are pretty rigorous in NEPA. In CEQA, when we talk about the California Act, CEQA is much less rigorous when it comes to alternatives. In NEPA, you basically have to evaluate your alternatives almost to the same level as your preferred project, right? So again, going back to, say, building a visitor center at a national park, if you have an idea of where you want it and what the preferred location is and design and attributes and all of that, you can put that in the project, but you have to come up with alternatives, and those alternatives better be feasible, and they better have different, rationales behind them: location, impact, so forth. Does it need to be that big? Could it be half the size? And you have to devote a substantial treatment. The other thing you have to do is you have to include the no action alternative. And what the no action alternative says is, do we actually need a visitor center? And you do an analysis that says, this is what would happen if we did not build a visitor center, right? And not surprising, it could have environmental benefits by doing that, right? But in some cases, like building freeways, if you don't build freeways and allow for the movement of congested traffic, there's an actual, environmental negative, right? So your alternative to, say, a federal highways project could be, this is the design we want, this is the number of lanes and width and so forth. Here's an alternative that's maybe not 8 lanes wide, but 7 lanes wide instead. And then there's the no action alternative. And that no action alternative could include in its environmental review, if you don't do this, congestion will sit in this community, air pollution will increase, and health risks to the public may occur, right? So there's all sorts of reasons why you want to do that kind of assessment. The big picture, though, is that there is the idea that there's cumulative impacts, right? So you can't just put little pieces of projects together, in essence, right? If I want a visitor center, but I also need to build bathrooms, I need to build a road, and I need to build an interchange at the freeway, and I need to build some other, features. If I go and treat each one of those individually and just kind of tick them off one at a time, eventually I might be running afoul of some of the rules under NEPA, right? And they could say, well, look, this was all just one big project, but you didn't want to assess it under one big umbrella and all those environmental impacts, right? So you have to address cumulative impacts to your projects and bind them together where appropriate, but also recognize that if, say, I build a federal highway and that instigates more development in an area by the local community, or more commercial activity, or more, transportation of goods and materials, right? Those are other impacts I need to be aware of and include in my environmental assessments. And then there's the direct effects, right? The kinds of effects we worry about are cumulative, direct, like, just grading land and getting rid of habitat is a direct effect. Draining a lake is a direct effect, Then there's indirect effects. And these may be later in time or further removed, but they're still foreseeable. This is where you talk about changes in the population, changes in land, maybe future potential impacts to air quality or water quality based on the project that you're proposing. So those are all the sorts of things that you have to include in an environmental impact statement under NEPA. So does this work? Right? So this is the federal government's approach to this. Yes, it does. It provides a lot more information. It's garnered a lot more participation from all the stakeholders who may be interested or impacted by projects or benefit from them as well. The environmental decisions tend to be a little bit friendlier when they go through this review. Certainly over time, once Department of Defense, Department of Energy, and every other department realized that, hey, we're stuck with this, their attitudes changed substantially, and they said, we rather than fighting it every step of the way, why don't we just do things a little bit more sensitively? The public and the stakeholders and the agencies now are all aware of why a project is approved or denied, and that's important. Again, it's this disclosure document. It includes sort of cost benefit analysis in there as well. And other statutes have been developed because of the creation of NEPA. And so next we'll talk about CEQA, the California analog to NEPA, right? So California in 1970, under the Reagan administration, decides to pass a very similar law. And here we have the California Environmental Quality Act. And this one in firefighting in particular is pretty important because it touches a lot of what goes on in firefighting. Fuels management programs, defensible space requirements, all sorts of activities that will have, forestry management. All of these things have to go through, if they have a state nexus, not a federal nexus, but a state nexus, have to go through CEQA. And not unlike NEPA, the state of California basically said, yeah, we see the state as having a similar duty to prevent harm to the environment. And so whether we're proposing a new technology or a project or a process, an activity or a chemical that's being used on the landscape or whatever it is, it lies with the proponents, the people who want to do that project, to explain why there's an underlying purpose to that project and disclose those environmental impacts, if any. So really what you can think of CEQA and NEPA for that matter is that first and foremost, it is not a permit, right? It's a planning document. It's a disclosure document. It's like when you buy your house and you get that inspection report done and your title report and everything else, and it tells you that in your title report, the northwest corner of your property has a utilities easement across it, and it has a road that crosses a portion of it that's owned by the county and blah, blah, blah. And they go through all these things that's on your property. And then you have your inspection done, and it's like, well, you've got termites in the garage, you've got a crack in your foundation, you've got, out of date code with regard to some of your electric, and a leaking roof, right? All it is it's a way for you to look at that and say, should I buy this house, right? And that's kind of what CEQA and NEPA do. They just give you disclosure and they say, should we approve this project? Because ultimately under CEQA, it's going to go to some, state or local government agency. So if you want to build, a housing development in the city of Temecula, you come to the city, you file through the planning department, and you'll probably go through the CEQA process. And the city is the approving body. Sometimes all you have to do is go to the planning commission for approval. Sometimes it goes all the way up to the city council. If you're going to go into the county of Riverside and you want to do a project down in the county of Riverside and say build a new industrial plant, you have to go to the county board of supervisors and the county planning commission to go through that process, right? But again, it's all this sort of disclosure and open information that folks are looking for. Now, there is a legal basis to all of this. It goes back to our constitutionally authorized police powers that local government, cities and counties have. And again, under the California Constitution, which we didn't read, but if you get a chance to take a look at, you should. The goal under Article 11, Section 7 says, protect the public health, safety, and welfare of its citizens. So this is what gives California the legal basis to have a law like CEQA in place. And when we talk about public welfare, we define public welfare as the values it represents that are spiritual as well as physical, aesthetic, and monetary. So this is a very broad spectrum of ideas that fall under environmental review. And indeed, when you look at how environmental review is done, it's not, again, just the direct impacts, but it's the aesthetics of the building, right? There's a lot that goes into it besides just, direct impacts. Now, originally, CEQA was only intended to apply to public projects, or at least that's how folks interpreted CEQA. What ultimately happened under a case just a couple of years later, it's Friends of Mammoth versus the Board of Supervisors, CEQA applies to all projects that are subject to some sort of discretionary action by some governmental agency from the state down to local government in the state of California, right? Now, the only time it doesn't apply is on tribal lands and on federal lands where there is no state nexus. So Forest Service property, BLM property, Department of Defense property, any tribal trust lands that are there, none of the CEQA provisions shall apply. However, that doesn't mean they don't have to go through NEPA. Now, there may be cases where you actually have to do both CEQA and NEPA at the same time, right? And that means maybe you've got a state project that you're doing in a big development or a big, infrastructure program, but you're also receiving federal oversight through certain permitting processes or federal dollars to help make that project happen. So you're going to end up doing both a CEQA and a NEPA document. But the good news is you can kind of double dip between those because there's a lot of overlap between the two. Now, I gave you access to all of this, and you can Google it and find all of the stuff online. There's the law and then there's the rules, and this falls under California Public Resource Code, and all the guidelines are found under the California Code of Regulations, Title 14. The guidelines, it took them 3 years to actually issue guidelines because I don't think initially they really understood how complex this whole process was going to be. And so much like the CEQ for NEPA, we have OPR, Office of Planning and Research, that established the roadmap for CEQA. And it's intended to be certified and adopted every 2 years, but usually it's more frequent than that. And and it's constantly being amended by statute and interpreted by the courts. And that's part of what you're looking at this week in assignments is you're constantly talking about CEQA in the legislature. So who does this? Well, you can have lead agencies, which are primarily responsible for the project and the certification of this document at the end. There's responsible agencies. I like to use the utilities as the example. because they may be providing the utilities to the development or the thing that's occurring. There's trustee agencies that have responsibility over resources, like California Department of Fish and Game. Oh, that's outdated. It should be Fish and Wildlife, old school. There's federal agencies. They're not subject to NEPA, but they are, or CEQA, but they are for NEPA. And then there's certified regulatory agencies that will often get involved in this process. The best known of them is the California Coastal Commission. Who prepares this? Well, an agency is responsible. So if a city is reviewing an environmental document related to CEQA, that document is owned by that agency, right? By that city or county. You want to build a house here, we have to do an EIR. The city of Temecula is responsible for that document. However, we can get information from wherever we need to, but there's some caveats to that, right? You hire experts to be able to do the environmental review, and hopefully these experts are independent. And hopefully the document reflects lead agency's independent judgment. And hopefully the decision-making body, and they cannot do this under law, delegates their authority to anybody else but themselves, right? So you are responsible for this ultimate decision. Now, the legislature, in their statement of what CEQA is all about, says they find and declare that it is the policy of the state that public agencies should not approve projects as proposed if there are feasible alternatives or feasible mitigation measures which could substantially lessen environmental impacts of the project, right? And this is where CEQA tends to fall apart, right? Because this language is pretty fuzzy. And what do you mean by substantially lessen? What is significant effect? What are feasible alternatives versus non-feasible, right? This is where CEQA gets a little bit difficult to deal with. Now, you have to address your environmental impacts from your actions and your decisions and things. You have to be able to be very public about it, and identify ways to avoid impacts. That's really the goal. And the idea is to prevent environmental damage by requiring changes in the project. So if a developer comes forward and says, well, we want to build 100 condominiums over here in this kind of configuration and blah, 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 we look at it and say, well, geez, this is having impacts to water quality and habitat and sensitive resources, cultural resources. There's going to be impacts from lighting and view from the adjacent senior community or noise or traffic or whatever. And you're going to have to help us reduce those impacts. And really what it comes down to too is the public has a say in this. Every resident or business or anybody else who has an interest in this can speak to this project and ultimately can sue over the decision that is made. And usually the approval is what gets sued over. The only people that sue over disapproval of a project are the project proponents. They want to build their houses, the city or county rejects them or whatever, and they sue as a result. But otherwise, most of the time, the lawsuits are the folks that, they see a project is approved by a county or a city, and they don't like the project for a variety of reasons, and they challenge that decision in court. Now, what is a project, though? I've talked about a bunch of different kinds, but it's a very broad definition, an activity which may cause either direct physical change or reasonable foreseeable indirect change in the environment. And that's any activity directly undertaken by a public agency like a city or county, any activity undertaken by a person, which is supported in whole or part through contracts, grants, subsidies, loans, or other forms of public assistance, and activities that involve issuance of permits, licenses, certificates, or other entitlements by one or more public agencies. So what does that mean? Well, okay, pretty much anything, right? Discretionary projects even broaden the scope, and that's where the first few CEQA lawsuits came from. Any project that requires exercise or deliberation when the public agency declares or decides to approve or disapprove a particular activity, right? This is like a tentative map, a general plan, a conditional use permit, potentially are all covered under discretionary projects and all subject to some level of CEQA review. And so if you have a project and you come to your jurisdiction and you want to, or a jurisdiction has their own project, they want to build a library, right? The first question is the action discretionary in some capacity, right? Does this require CEQA, yes or no? If it is a discretionary action, the next question, just like under NEPA, is are there exemptions already in place? And then you have to decide, if it's not exempt, is there a possibility that the project's going to have an environmental impact? And based on that level of impact, that's when you try and figure out what the appropriate document is that you need to prepare for public review. The other question that you ask is, if you know you have to do some level of environmental review, do you want to do an initial study? And that's kind of like a 10,000 foot level view of the project to kind of review the project, test the waters, and see whether or not there's, basically just see what the issues are, what the impacts might be, and get some public input early on in the process. Now let's start with the exemptions. The exemptions fall under two categories under CEQA: statutory and categorical. Statutory exemptions include things like ongoing projects, those that were in existence before CEQA came about, Olympic Games, family daycare homes, low-income housing, air quality permits, emergency projects. Those are all categorically exempt. And yes, the Olympic Games are exempt, and that's something that Los Angeles is dealing with right now. Now, you could argue that the scope of that and how far you can take that is pretty substantial. And it'll be interesting to see what Los Angeles does under the exemption that they're given. Does that mean they could just build whatever they want to without any environmental review whatsoever? Technically, the law says yes. We'll see how they proceed. Categorical exemptions, they avoid review because there really isn't an impact, right? The reconstruction of a small structure, existing facilities modifications, actions to protect the environment don't have environmental impacts by definition, right? Minor addition to schools, and acquisition of land for wildlife or habitat conservation value. If your project is exempt, you still have to file a project summary, let everybody know what's going on, and file a notice of exemption. And it gives a pretty short window. I think it's only about 30 days that interested parties have to file a legal challenge to the exemption. If you don't file anything in that period of time and it's been properly noticed, then you lose your opportunity to challenge that project in court. Now, if you don't get an exemption, then you're going to end up doing one of these things, right? An initial study, like I talked about earlier, negative declaration, mitigated negative declaration, environmental impact report, or addenda. And the addenda are only if you already have an existing EIR that was done and you're just updating it or providing additional information because the scope of the project had changed. So let's start with initial study. What is that? Well, the initial study really only is needed if you determine there's a project with potential impacts or whether or not to prepare an EIR. Oftentimes this is done for political reasons, right? You float the project out there to see what the temperature is on the concept. It's a preliminary study, that's all it is. And it's pretty basic, right? Description, location, objectives, environmental setting. You can do a quick review under Appendix G, we call it, of environmental impacts. Talk about some mitigation measures you're contemplating. Is the project consistent with existing, zoning and plans and land use and all of that? Pretty straightforward. And under almost every section of the environmental documents we're talking about, from initial studies to EIRs and negative declarations, Appendix G is kind of what we refer to as sort of the list of stuff, right? This is the recipe for CEQA. You have to review aesthetics, agriculture and forestry resources, air quality, biological, cultural, geology and soils, greenhouse gases, hazardous materials, hydrology, water quality, land use and planning, mineral resources, noise, population, housing, public services, recreation. Public services, by the way, we're talking about things like utilities, I'm sorry, not utilities, things like fire and police protection, code enforcement, public works, that sort of thing. We've got public services as well, recreation, transportation and traffic, and then utilities and system services. So, okay, so now we need to do some kind of environmental review, right? We didn't get an exemption. Maybe we did, or we're skipping over the initial study and the kind of floating the project out there. Now we need to decide which of these three things. So we have a project and it's going to have a potential environmental impact. Which one of these three things do we need to write up? Now, they all require the same basic elements: a notice of preparation, so the public knows this is occurring. You have to prepare the document. You have to provide a notice of completion. The lead agency shepherds this through the public process the whole way. And then at the end of any one of these documents, there's a NOD, or notice of determination, that says, yeah, the project is, meets the standards of the city, or it doesn't, right? And we accept or reject the concept. How do you know which one? Well, really, if you're going to have an environmental review of any document or any project, the first question is there a significant environmental impact? If there is, you do the full-blown EIR, environmental impact report, right? Generally doesn't matter how much evidence supports the opposite conclusion of less than significant. If there's even a hint that you're going to have a significant impact, just go ahead and do the EIR, right? And there's all sorts of tests you have to sort of evaluate this, the substantial evidence test, all of that. I would say the mitigated negative declaration is challenged by the fair argument standard, while an EIR is pretty a substantial document, really. And so if you're sitting on the line in whether or not to do a negative declaration or a full-blown EIR, oftentimes just do the full-blown EIR. Now, when we say significant effect on the environment, they actually have defined that. And boy, is it a broad definition, right? Substantial or potentially substantial adverse change in any of the following conditions: air, land, water, minerals, flora, fauna, and noise. Objects of historical or aesthetic significance, social or economic changes are not significant to the environment, right? So again, this is an environmental document, not a social document. So tools for determining those significant events, well, there's a lot of them out there. Lead agency CEQA guidelines, there's mandatory findings of significance. There's a ton of court cases, of course, on this. But agencies have established their own sort of standards, for environmental protection, air quality, water quality, endangered species habitat. So you'll know whether or not you fall under one of these environmental protections. And of course, like I said, Appendix G, if you say yes to any of the questions in Appendix G that ask about environmental impact, well, then you're doing a full-blown EIR. So why do we talk about this? Well, the question often is, when is a negative declaration used? Well, when there's no substantial evidence that a significant effect may occur, right? You still have to go through this process. You're not exempt, right? Because you don't fall under those categories of exemptions, but there's a question about whether or not you're going to have an impact in the environment. And so again, this is just a disclosure document. And if you're fairly certain, and the analysis supports it, that there's really no significant impact, then you just have to write that up and say there is no significant impact, right? The contents are pretty basic. These are a little bit easier documents to provide, right? Brief descriptions, proposed findings of no significance, initial study documents and things for supporting the findings, and then mitigation measures to avoid potentially significant effects. So if there may be effects, but you're going to say, well, we're going to do this, like we're going to build this berm to make sure that none of the pollution from the parking lot is going to enter any waterway, and it's going to be treated on site in this, French drain system and all of that. And there's absolutely no chance of pollution because we're going to build this little, thing here. Well, then just describe that. And then you've been able to say, no, we don't need a full-blown EIR because we will not have a significant impact to the environment, right? And then, any monitoring that's required by the agencies as well. It's not detailed. You don't talk about growth-inducing impacts because your project shouldn't be doing any of that, right? You don't need an alternatives analysis because, again, if you're not having an impact, then there's no need to, right? And there's no discussion of any sort of significant impacts to the environment. That's the whole point of this, right? Triggers for a mitigated, so there's two types, right? There's a neg deck and a mitigated neg deck. The default now is that everybody just does a MND rather than the negative declaration. Everybody does the mitigated one because a straight negative declaration is too easy to litigate. It's too easy for you to get sued by doing that, by just saying there's not going to be any impacts and we don't foresee anything. It's always easy just to defer a little bit and say, well, there might be something, but we're going to do this and make sure it doesn't happen, right? So again, you minimize impacts. You are repairing or rehabilitating or restoring land. You're reducing or eliminating impacts over time. Any one of these things can be a trigger for MND. But like I said, the default now is just to do it, and very few folks today ever do just a straight traditional negative declaration. So really, in essence, what we have is we have an exemption. We have a mitigated negative declaration, and we have a full-blown environmental impact report, or EIR. Those are really predominantly the three kinds of things that you'll see in California today. So the EIR is the big daddy of them all. And the reason we do one of these is if it can be fairly argued on the basis of substantial evidence that the project may have a significant environmental impact, then you're doing an EIR. The agency, typically there's a whole bunch of different types of EIRs: project, subsequent, supplemental, master, focused, all of this kind of thing, a bunch of different kinds. But the bottom line is you've got an environmental impact. Now, again, I want to emphasize that the goal of this isn't to say that the project just won't happen, right? The goal of this is to disclose those environmental impacts. And then the decision makers can make that decision independent of these, you use this document as a reference, but then it's their judgment at that point that says, should this project continue, yes or no? If there are environmental impacts that are significant, then you need to talk about it, right? But it doesn't mean, again, it doesn't mean that that project shall not move forward. Think about all the projects in California that have happened since 1970. Reservoirs and dams that have been built, right? Massive infrastructure programs. They're going to have significant environmental impacts. The high-speed rail that's still, talked about and kind of under construction here or there. Massive environmental impacts from these projects, but it doesn't mean they don't occur. So you usually start this whole thing off with a scoping session. Again, sometimes you do that initial study that I talked about at the beginning. But what the scoping session does is it determines the scope of the EIR in consultation with agencies and the public and the applicant. You then create a draft environmental impact report, and that's based off of all the studies that you do. That Appendix G, you're going to look at air and water and endangered species and habitats and cultural resources, aesthetics, traffic, geology, soils, right? Hazardous conditions, earthquake faults, all of that kind of stuff. You're going to come up with a draft document, and you're going to circulate it for review to that public agency, that city or county or whomever that's reviewing it for you, right? It's their document. That is their responsibility to create that document. And then it's up to everybody else to take a look at it and say, hey, this is interesting. I understand you're building something next to my property, and it's going to have a pretty serious effect on my property. And here's why I'm concerned, right? So you provide that comment. And then through that, if it does move forward and the project proponents are still interested in doing this, then it goes to a final. Now, if I'm a city and I see a project moving forward and I just don't like the project and I see this draft come out and I'm like, man, I'll tell you what, I don't think your project's going to get approved. We still have to go through this whole process, right? You can't just deny them the process. You have to let them go through. Final EIR still has to take in consideration the draft, has to take in consideration and respond to all the comments and recommendations that were made by the public and other stakeholders. And it lists all the persons and agencies commenting on the EIR, and what, if you have a question or you have a concern, then it lists a response to that question or concern. And it's a pretty big document, right? Some of these things can be thousands of pages long with all the technical and other reports and studies attached to them. It's a lot. And it talks about all the alternatives. Now, the interesting thing about the environmental review is, again, it's just sort of a roadmap to the project and what may occur if the project happens. If you're in a position where you get toward final approval, again, if there are any impacts that haven't been mitigated below a level of significance, you have to file a statement of overriding considerations. And what that means is, we find that this project has these values. Despite its impacts, it has these values. And we've gone through this environmental review, but we think the benefits outweigh the impacts or the risks. And so because of these reasons, we're going to approve this project, right? And then you file for all the public to see the notice of determination that everybody votes on and approves of that, governing board, right? Now, again, the public is involved in this pretty heavily from the day there is a project to be discussed. Again, these are information documents and disclosure documents. The lead agency has to seek public review, and it must address each significant effect and respond to all of those comments. And again, this could be thousands and thousands of pages on the record. So how do you get to court, right? I mean, that's really the bottom line, is you've got this whole document and disclosure and everything else, but somebody can sue you over it. Now, depending on the kind of document, for an exemption, you have 35 days from the notice of exemption, within 180 days of approval if no NOE is done. For any of the negative declarations or an EIR, it's within 30 days of its approval, basically, right? It's filing. For projects that should have gone through CEQA but didn't, it's 180 days from the decision to carry out or commence projects. But really, that one's pretty fuzzy too, and the courts have given a lot of deference if a project skipped CEQA or an agency decided not to do CEQA. And so that 180 days is not a hard and fast rule. If you do go to court, what does it mean? Well, the courts, we talked about Chevron in the beginning, and courts really do sort of think about things in terms of deference, right? Was the standard of review a good standard of review? Was there prejudicial error in some way, right? Was there influence, political or otherwise, or some kind of shenanigans that, you look at the project, you do the review, you look at all the substantial evidence and everything else that's available to you, and you say, my goodness, this is a horrible project. It should never have been approved as is, and could contain, remember, the goal is to, reduce environmental impacts. There's plenty of things you could have done to reduce those impacts, and you haven't done them, right? So it's not hard to sue over CEQA. Bottom line, this is a great cottage industry for lawyers. If you really want to make a decent living as an attorney, become a CEQA attorney, because you can always sue and challenge projects. It's very easy to do. Doesn't mean the project will not go forward or it will stop, but it does mean that you can challenge projects pretty effectively. And, unfortunately, just like ambulance chasers, there's a lot of bad attorneys out there who make a living challenging projects up and down the state or in their jurisdiction that they live in. And you just see them come in all the time, and they file their lawsuits and all of that. Now, I will say the one thing I didn't mention is, if you don't provide some type of public comment and raise your concerns during that public process, you are prohibited from suing after the fact, right? That is your opportunity to let people know what your opinion is. And if your comments and concerns and all of that aren't on the record at some point, and you demonstrate, what you have to do basically is demonstrate that, geez, kind of ignored me, right? I told you I was concerned about this issue, and you went ahead and approved a project anyway. So that's kind of how the legal process sort of plays out. Much like under Chevron, that we talked about, substantial deference is given to the lead agencies. Courts generally uphold an agency's action as long as it's not arbitrary or capricious, as long as it substantially advances a legitimate government interest, and it does not deny an owner of its economic viability of their land. Now, remember, it means that sometimes you get sued because you deny a project, right? And you're going to come in, let's say, with a project and you want to develop a new Walmart in this community, and you come in and let's say the zoning does not support that Walmart, but you are going to either seek a rezoning or a conditional use permit from that jurisdiction. And you're going to say, hey, I want to do the project. And the project proponents say, you know, this isn't going to fly, right? This isn't what we're looking for. And you know, you go through the whole process, and not surprisingly, they reject your concept and say, nope, you're not going to build that here. Well, they didn't deny you of all economic viability of your land, just that particular one, right? And so this is where it gets pretty tricky, because if you come in with a project and you say, well, it's zoned for residential development, medium density, I want to do a medium density project, I'm going to have one house per, you know, fifth of an acre. You know, you go through this whole process, and the city says to you, you know, you want 100 homes and we're willing to give you 35, right? Because there are all these sensitive areas over here, and there's this going on over here, and impacts over here, and blah, blah, blah. And so we think, rather than giving you 100 homes, we're going to give you 35. And you're going to sue saying, man, I want the 100 homes. Well, the courts are going to look at that and say, well, you still have a project, and you may have thought that that property can support 100 homes, but your local agency does not agree with you. And unless there's an arbitrary or capricious reason why, you know, they did that, they're probably going to uphold that city or county's decision, because again, it did not deny you of your economically viable use of land, right? It's a very tricky thing. CEQA is probably one of the most litigated things in California. And it's probably one of the areas where we need the most reform. CEQA is a bit of a sacred, you know, thing in California, and it's very difficult to pass legislation that modifies it in any substantial way, especially if that modification is sort of lessening, you know, the environmental review, or you know, one of the things that I was interested in a few years back with some of my colleagues was the idea that we change the liability when it comes to lawsuits, because there's no risk. You can file lawsuits under CEQA all the time, all you want to, and there's no financial liability or even legal liability. Even if it's a frivolous lawsuit, there's very few that fall under that category, because CEQA is so broad in its language. And so you can delay and hurt a lot of projects just by continually filing lawsuits. And so there were a lot of folks saying, hey, you know, this is just too easy for folks to sue and not have really good reasons for suing. And a lot of attorneys are making a ton of money, being fairly disingenuous with their clients and dragging out projects and costing people a lot of money, and the projects happen anyway. And, you know, making any of those changes, I'll tell you, is extremely difficult. So let's compare the two, just so you have the idea here. First, between the federal and the state, CEQA and NEPA. CEQA has a categorical exemption. NEPA has, they call it the categorical exclusion, basically the same thing. CEQA has an initial study. NEPA has environmental assessment. CEQA has a NEGDEC or MND. NEPA has the FONSI, finding of no significant impact. CEQA has an EIR. NEPA has an EIS. The other couple of points which are kind of interesting, CEQA requires mitigation measures to be implemented if feasible. NEPA doesn't have that requirement. It's kind of interesting. You can talk about mitigation of how you're going to lessen impacts, but there's no actual requirement that they be done unless it's not discussed just as a potential mitigation, but it's an enforced mitigation, right? And so a lot of projects will talk about, well, this is what we could do to lessen the impact. The project gets approved, and then they don't do it, and people will say, well, why didn't you do it? And it's like, well, because it's not required, right? Again, hopefully everybody's just sort of a good actor and they're, they're honest in their conversation about their projects, but not always. CEQA requires discussion of growth-inducing impacts. NEPA does not. CEQA requires alternative analysis, just like NEPA. Remember I said NEPA is pretty rigorous in its alternatives, right? CEQA is totally different. It's so much more less detail in it. I've seen EIRs that are hundreds of pages long, and in their alternatives analysis, they may list 2 or 3 of them, and it's only a few pages long, right? So not the same level of detail. And so under CEQA, you can actually promote, this is the project we really want, right? Under CEQA, it requires mitigation monitoring programs to be prepared. But again, under NEPA, you can do that, but it doesn't require it, right? Under CEQA, it requires identifying significant effects in the EIRs. And in NEPA, some agencies avoid the term significant altogether, right? So, but the bottom line here is that we have these 2 wonderful federal and state laws that were passed for, I think, good reasons. And they've kind of gotten a life of their own, over the last, 50 years now. And in that time, both CEQA and NEPA have been enlarged to be these very cumbersome, very difficult environmental review processes that can cost millions of dollars to produce these documents and reviews. And the legal world is pretty challenging in all of this, like I said. And it's a great tool if it's used properly and if it's not abused. But unfortunately, and I'm not excluding the developers and landowners, agencies, developers and all that, they will abuse these processes as well to their advantage. And I was involved in a number of cases over the years that we'd seen such egregious, such unethical behavior in the development of environmental documents and just straight up lying about the findings in some of the studies and altering reports and things. I mean, it's stunning what actually happens in the background of some of these things. And so there's a lot of areas that CEQA and NEPA could really benefit from some updates in the rules and in the legislation. But like I said, it's a very, very touchy subject and not an easy place to work in. I'm going to pause there because this was a pretty decent sized lecture, and I'm going to record the piece on the Clean Air Act separately so that you don't have 2 hours of video that you have to watch in one stretch. So anyway, that's all we have on CEQA and NEPA. Thank you so much for your time.